I call Bill Aitken to speak to and move Amendment 4987.1. Mr Aitken.
For many people, including many of those who are actually involved in the law, the civil justice systems in Scotland are clearly operating in a time warp. And I think there is a unanimity throughout the Chamber that the status quo is simply not an option. And I think we have been extremely fortunate that we have before us such a weighty and comprehensive report prepared by Lord Gill and his colleagues, which gives us the basis for the fullest consideration of what is before us. Now, like Richard Baker, I do not have the time this afternoon to deal with every aspect that is within the bill or within the report, but I do wish to stress a number of issues. First of all, I do not think that there is any doubt whatsoever that throughout the legal system there are people who are doing work for which they are distinctly overqualified. I do not think that there requires to be the weighty deliberations with regard to a breach of the peace in the East End of Glasgow at the Sheriff Court level in some instances. And I certainly don't think that when this has been determined by an inferior court that it requires 3 senators of the College of Justice to be able to determine an appeal. That is an absolute nonsense. And it is high time that something was done about it, and this report has got the provisions as to what should be done. Now, like everything else in life, there are specialisms. I think many of us sitting in this chamber this afternoon sometimes think that we have got to be the masters, the jack of all trades and the masters of none. And that is a similar situation which at present applies in the judiciary. Great progress has been made in Glasgow Sheriff Court with regard to the degree of specialisation, particularly in commercial and family law. And that has got to be extended throughout Scotland. And it is inevitable that once this is in place, cases will be dealt with more efficiently, they will be dealt with more effectively, because the people who are dealing with them will be doing this type of work more or less all the time. It is, to quote the Cabinet Secretary, a no-brainer. And we do have to look at the hierarchy of the courts and the appropriate use of judicial resources. I have referred to the question of the appeal court. But really, is it a case that a highly qualified senator of the College of Justice should be dealing with minor cases, where sometimes the amount involved is only a few £1,000s? Now, Richard Baker, again, was quite right to highlight that sometimes cases where there is very limited monetary value bring about a very real point of legal principle. But Donohue's versus Stevenson only occur every 75 years, as I recollect, so perhaps the ability which is within the Gill report to deal with these cases is the appropriate one. But let's transfer the bulk of these small personal injury or other types of claim out of the Court of Session to sheriffs who are more than qualified and adequately resourced to deal with them. I do have one regret. It does seem to me, and I know that Paul Martin will agree, that there is a Edinburgh-centric thinking in the legal profession, and if there is to be a personal injury court, and there is a very valid case for that, then why has it got to be in Edinburgh? Why can it not be in Glasgow? Because well, Mr Pringle may say that Edinburgh is the best place, but why is it that Glasgow is the court where the initial specialisations came about? So that is something that could perhaps be looked at. On a more serious point, if we have to go down that particular route, and as I say, there are advantages in so doing, we have to make sure that that particular court is adequately resourced. Now, as a well-known technophobe, I have to say that I find it astonishing, the lack of use which is made of IT within the court setup. I think it's also astonishing that there are so many hearings which, for the vast majority of people, are totally and utterly meaningless. Every business nowadays uses telephone conferencing. Every business uses fax machines and other manifestations of IT. Why can the court system not do that and save so much time? So that has to be looked at. I'm attracted, again, because perhaps Glasgow has pioneered the route in the aspect of the third-tier judge. As the Cabinet Secretary will know, in Glasgow for many years, stipendiary magistrates have operated in tandem with lay magistrates effectively providing a summary justice system which has been proved to be very satisfactory. That same type of judge could have the remit extended to include such things as small debts, education, housing disputes. And I don't think there would be any particular difficulty with that at all. I think you would only have to have one of these judges in most sheriffdoms, and perhaps the larger ones, perhaps two, taking away a lot of the summary criminal work for which our highly qualified sheriffs, many of whom are Queen's Counsel, should not be doing, and also dealing with the smaller end of the scale civil actions. So we have that aspect also.
Margaret MacDonald.
Thank you for giving way. Since much of the law has to maintain the principle of equity, presumably if you're going to have this diminution of qualification in a judge, then you would want to pilot it first of all to see whether or not there were more cases went to the Human Rights Court, because I know that you're very interested in that too.
Mr. Aitken.
My interest in the human rights legislation is, I think, well known throughout this particular chamber. But I don't think we would have this problem, because in Glasgow, and I would invite Margaret MacDonald to visit Glasgow to see this in operation, the stipendiary magistrates' courts work very effectively. And indeed, had it not been for them, then the summary justice system in Glasgow would have collapsed years ago. So it's a simple matter of simply extending them. Remember, they are all legally qualified solicitors to extend their remit to include these minor issues, which would not be a very great moment. Judicial specialisation is absolutely vital, and that has got to be advanced, as I say, at the earliest possible opportunity, although I do not suspect that we need legislation to be able to do that. But any system of justice, whether it be criminal or civil, must have behind it that basic essence. It has to be fair, and it has to be understandable. If it is to be fair, we have to consult and make sure that we take people with us. If it is to be effective, we must see savings in time and in money, because this is now costing us money. There is absolutely no doubt that people are taking contract law out with Scotland, the oil trade being the classic example. And this is not a happy position in which we find ourselves. Right, briefly.
Bill, I can agree with me that it might be costing lawyers and people, but it's the litigants that are the people that are really suffering in this particular instance by having to go to London.
Mr. Aitken.
Well, the litigants in most cases can actually well afford so to do, but it's a highly unsatisfactory situation. And what we have to ensure is that Scotland's courts are providing a forum where the most complex matters can be determined, and then there will not be this temptation to go to London. In fact, I would very much hope to reverse that particular trend. So in conclusion, can I say that what we have before us is a very fine basis for further progress. I note and respect the views put forward by the Cabinet Secretary that there are certain aspects of this bill which might be accelerated, although there are dangers, as Robert Brown has said, about dealing with the matter in a piecemeal manner. But let us move onwards and upwards, because there's a lot to be done.
I now call Robert Brown.
Thank you very much, Presiding Officer. Could I say, first of all, that Lord Gill has produced an extremely weighty report, I have to say in several senses of the word. I don't know why it has to be printed on such heavy paper, just a minor issue to the side on that one. But it is a report which does identify a number of very serious barriers